Thank you very much.
Thank you, Senator. Madam Senator Batters.
Thanks very much. Thank you to all of you for being here and your important perspectives. And Mr. Pfefferle, I would like to address my questions to you. Thanks very much for taking the time to present to us today, and your practical experience as a highly regarded lawyer in Saskatchewan who's represented a significant number of Indigenous accused, particularly in jury trials, provides us with a valued perspective on this issue of peremptory challenges. And because you have seen how peremptory challenges work in actual practice when representing Indigenous accused, and you have, as you said, used them frequently for the benefit of your Indigenous clients. So I would like you to just use the brief time that we have today that I have for this question to tell us a little bit more about why you oppose eliminating peremptory challenges for those particular reasons.
As I say, in my experience, we use these peremptory challenges for the purposes of creating diversity on the juries. An example would be in a typical Saskatchewan jury now, we're having 500 people called for jury duty. So 500 people are randomly selected based on their health cards in our province, and they're to come to the courthouse. Almost half of those individuals won't even attend. They'll either be dismissed by sheriffs in advance. Sometimes they'll have some issue. Maybe they'll be legally excluded based on one of the criteria outlined. But the vast majority, based on just visual research that I do based on the internet when I search the potential jurors, those that don't come to court by and large are from visible minority groups. And so the original array that we have to choose from is grossly underestimating the number of Indigenous people in our communities. We end up as counsel, we would get 20 names typically called randomly from that array, and those 20 individuals would come up. Many times we know something about those individuals already, not sufficient to challenge them for cause, but sufficient to know that they wouldn't be necessarily the most favorable or fair-minded person, frankly. Then, of course, there's the issue of when the clerk asks the juror to look at the accused and the accused to look at the juror. That experience is one that you can't really describe, and it's not an experience of racial profiling or anything the like in my experience. If the juror won't even look at my client, I don't want them on my jury. Can I prove bias? No, I can't. But to an Indigenous person, particularly sitting on that jury, standing in front of this grand crowd, that can be a very intimidating experience. And you know, is it the Head and Shoulders commercial? You never get a second chance to make a first impression, maybe from the 90s. That's the same principle really with this process. And we have vulnerable people on trial for very serious matters that should have their opportunity to pick their juries. And in my experience, although I would admit that the Crown on occasion has objected or challenged jurors that I would have liked on my jury, and they use the challenges for the exact reason why I think some people complain about them. For defense counsel, that has not been my experience. And it's going to lead to significant expensive delays in our jury trial process, again, with Indigenous people being overrepresented in that process while underrepresented on juries.
Thank you so much.
Thank you very much, Senator. Monsieur